I've never seen a federal judge dissolve a TRO.
What people don't realize is that they set up these fake courts inside the agency. They only apply in favor of the SEC. And then you lose 100% of the time.
And this is the first case that I've seen where the SEC is suing the token itself.
The Investor Choice Advocates Network presents SEC Roundup.
I've never seen a federal judge dissolve a TRO, asset freeze and receivership. I've just never seen it. And I've been doing this, we've all been doing this decades. So
that's true. The other thing which is unusual, I think, is you mentioned the investigation was going on for a year, but the commission needs to show a threat of imminent harm to get the TRO, which is hard to reconcile with a year-long investigation.
It is. And a lot of the facts, you guys read through the order, but a lot of the facts that they relied on, the judge said, oh, though you misrepresented those facts. And they did think they understood that typically the SEC as the government gets significant deference in a case like this. And perhaps they should. I'm not arguing the merits of that, but it troubled Judge Shelby.
And immediately a lot of people took notice because it's truly remarkable for a federal district court to even suggest holding the SEC in contempt, particularly under the facts of this case. So before we get into this, this case involved the issuance of a federal court order freezing the assets of a company and appointing a receiver. And so for anyone who's been through that, that is a huge court order that essentially stops the business in its tracks and in most cases ends in the destruction of the business. Now, on the SEC side, you can imagine just sort of painting a picture here. They're conducting an investigation. They believe there are some ongoing violations. I'm talking not about this case, but more generally about when they're seeking a TRO. They believe there are ongoing violations. They need to hurry up. They need to run into court. When they do go into court to ask for these extreme remedies of an asset freeze and a receiver in the form of a temporary restraining order, they are able to go into court and get in front of the judge without the defendants or their lawyers being present, which is what happens here. So it highlights the need for the SEC attorneys to be scrupulous in the accuracy of what they're telling the judge, because we don't have the usual scenario, which is inherent in our sort of adversarial legal system, of having someone be able to push back and inform the judge, no, that's not correct. So as happened in this case, and as does happen in SEC TRO cases, the SEC made its case in front of the judge without any defense counsel present, and the judge entered an order freezing assets and entering an order appointing a receiver over the business, which is usually a death knell for business.
In that process, we discovered going back several years, nobody won an administrative proceeding. And so that started to concern us that we were looking at kind of an impossible case. And in doing a little bit of research, we discovered really not just how much the SEC had started to rely on the administrative proceedings, but every other agency. And so we started to learn the statistics of that. And it was really staggering that the lion's share of cases brought by the federal government were now brought in administrative proceedings, and only a small fraction, like 10%, went to federal court. So, and then you see that they have this really stellar win rate in administrative proceedings, and that got us starting to think that we maybe needed to consider something other than just the usual defenses for Mr. Jarkissi. And so we went to the Constitution and started looking into the statutes that enabled their actions and their remedies that were enabled. And that's when we began to pull together the issues that we ultimately ended up challenging.
Anyone listening to that recitation, Karen, has to be struck that the process at some point is the penalty. It's just what a saga.
What people don't realize is that they set up these fake courts. I call them fake, inside the agency. So they have ALJs, administrative law judges, and they've got a little courtroom and a bench and a witness seat, and they put on trials just like a federal court would, except no right to trial by jury. The rules of evidence don't apply. If they, to the extent they ever do, they only apply in favor of the SEC, and then you lose 100% of the time. So it is by and large a kangaroo court.
So, Mike, what are the issues that are presented here? What will the Supreme Court be considering?
The key issue is going to be the Seventh Amendment. Most people don't even know what the Seventh Amendment is. The Seventh Amendment is the right to trial by jury for common law claims in civil cases. We have a Sixth Amendment right to a jury in criminal cases. We have a Seventh Amendment right to a jury in civil cases. We've now gotten to a point where the majority of government lawsuits against people for penalties are tried in these fake agency courts and not in real federal courts. And one of the consequences of that is you don't get a jury. You just get this one judge that's beholden to the agent, hired by the agency, reports to the agency. Well, of course, he or she is going to, as we've seen from the statistics, always rule in favor of the agency. So we took that issue up to the Fifth Circuit, and that was really the primary issue, is whether or not you're entitled to a jury trial where the government is coming after you for civil penalties. And it could be for penalties of $100 or $100 million. And they were seeking $100 million against Jarkissi.
Kevin, let's hear from you first. You've seen a lot of SEC complaints against digital asset companies and people associated with them. What about this complaint stood out in your mind as particularly new?
Sure, it jumps right off the page on the caption itself. You mentioned the defendant in the case, and there is one human defendant in the case. But in addition to the human defendant, there are 3 additional named defendants that are software. They're not entities, they're not people. The SEC in this case named Hex, which it defines as the ERC20 token, and Pulse Chain, which it defines as a fork of the Ethereum blockchain, and PulseX, which is a protocol deployed on the Ethereum blockchain. And this is the first case that I've seen where the SEC is suing the token itself or the blockchain itself or a protocol as a party defendant in the case. And it tries to do this by saying that these are somehow alter egos of the individual defendant. But to argue that the code, the software itself, is an alter ego of a human really is bizarre, as we point out in our papers, and unprecedented as far as I'm.
One of the other aspects, or one of the other things we pointed out in the brief, was that sometimes the SEC, and maybe often, some people would say the SEC doesn't pay enough attention to the secondary impacts that its cases might have. So, for example, we just saw the judge in the Coinbase case refused to let the SEC case against the wallet go forward. We've seen some criticism in the library case about the secondary impacts on library token users. Ripple, same thing. Secondary trading was an issue in the Ripple case on the motion to dismiss. So Marlon, here there is a very vibrant community, as I understand it, in the Pulse Chain community. Obviously, there was a petition that Matt can talk a little bit about. Can you describe for us the Pulse Chain community, some of the things they're up to that might be impacted by this case?
Yeah, sure. I'd be more than happy to. I think, one of the things that attracted me to the community as a whole is the fact that, it holds the principles of crypto dearly, right? There are a lot of blockchain ecosystems out there. I mean, a lot of experience, and I support a lot of them because, again, it's really just a lot of innovation in this new age that we're entering. But particularly with the pulse chain community, a lot of the things that we subscribe to in the crypto space, namely, self-sovereignty around our finances, for example, real DeFi, right? So I was quite shocked to see that the SEC went after software. And I've been a software developer since 2001, right? So I've seen the maturity of the software industry from the 90s into what it is today, well before crypto. So it was quite a shocker to me, just as a software developer, to see that code was being sued.
Right. So for those who don't know, the proposed rule deals with public company disclosure around climate issues. And the initial proposal was over 400 pages long, as you said, back in March of last year. The public comment period has generated, I think last I saw, something over 14,000 comments. And that's a lot of comments. And it's not surprising, given that this would, if finalized in its current form, increase the amount of disclosure on public companies in this subject matter, by a lot. So it's a potentially very burdensome rule, and so there's been a lot of pushback, a lot of delay in finalizing the rule, so that the SEC staff can consider the public comments and potentially modify the proposed rule in one direction or another. So we don't know where it's going to come out, but one thing is for sure, we're probably going to end up in litigation over this rule. Recently, we've seen environmental groups, Sierra Club being one, reportedly considering litigation options if the rule gets reduced from its current form. And other groups have suggested litigation might be an option. And so we're here to talk with Commissioner Atkins about that subject.
Commissioner, we'd love to hear your perspective as a former SEC commissioner on the rule. He wrote an op-ed for the Wall Street Journal last year saying that the rule might not survive a court challenge. Can you expand on that or tell us what your views are today, given that we're a year later and the rule is still in its preliminary stage?
Sure, I'm happy to chat about that. I don't want to have people be too sanguine about, what the significance of this rule and the potential, ramifications if it be adopted in its current form, because even in the proposal, the economic analysis, the estimate by the SEC itself, which usually tends to be, let's say, rather conservative, is that it will double the cost of disclosure for annual reports for public companies, basically across the board, whether or not they're involved in things that normally affect, the environment, like think of energy companies or whatever. But this would be up and down the line, especially because of the broad scope of the proposed rule and its invasion into Reg SX, for example, without really involving FASB, and which, of course, the SEC can do what it wants to. But then also, this really expansive reading of the Commission's authority, and then also with respect to, I think it's evisceration potentially of the whole standard of materiality and how the SEC has approached that, for the past, 80 years or so, whatever. So I think those are pretty, monumental types of changes that this one rulemaking is heralding. So it is very serious. And
when CAT was first designed, it was intended to collect your name, your address, your date of birth, your social security number. So it was really important that the Commission reapproach that and think about, given the environment we're in with so many cyber breaches, how could we seek to protect individual investors? So we spent a lot of time working with the SEC. We sent in a letter earlier in 2020 before the proposal came out, and we had recommended that they collect name, address, but rather than your date of birth, which is a lot of information, limit that to your year of birth. And we spent many, many months working with the CAT processor on a methodology to convert a social security number into a secure, what's known as a CAT customer ID, which is a unique number regardless of what broker dealer you're trading at, that gives CAT the ability to trace activity from one customer across the market and multiple broker dealers.
And one of the surprising things, and the reason we're talking to Ken and Ellen, is that a lot of people don't know about it. Which is surprising because it is a database into which brokers put all of the transactions that happen, and it's for the purpose of allowing the SEC and potentially others to determine what happened in the markets on any particular day. But it's a massive database, and the database includes, among other things, some personally identifiable information of retail investors. And so it's a bit of a surprise that it's not more well known, although when this thing was going through the SEC sausage making, various parties and members of the public did comment, including SIFMA. I recall that in 2019, in fact, the ACLU submitted a comment on one of the issues we're going to talk about today, which is data privacy and the potential risk to retail investors' data that is created by having this massive centralized database.